Today we have Senior Advocate Abhay Yadav, who is representing the Anjuman Intizamiya Committee in the Varanasi court with regard to the Gyanvapi mosque case. He is representing this particular committee who is challenging the maintainability of the suit filed by Rekha Singh and others in this particular Gyanvapi mosque case. So my primary question is with regard to this. What are your exact submissions before the court while you are challenging the maintainability of the suit filed by Rekha Singh and others in this Gyanvapi mosque case?
Look here, in civil case or the trial, we have a procedure that is called Civil Procedure Code. In that code, there is one provision purported to be incorporated under Order 7 Rule 11. This provision speaks about the rejection of the plaint, not dismissal of the suit. This dismissal of the suit and the rejection of the plaint are altogether different. This provision speaks about the rejection of a plaint, and there are certain grounds mentioned therein. A, if the plaintiff had not disclosed with a clear cause of action. And second important one that is, if it appears that the plaint is barred by any law. If these two, any of the grounds is fulfilled, the plaint shall be rejected, so that a non-maintainable case may not be tried. Very valuable town may be saved, and moreover, the frivolous litigation may not be allowed to continue. Such type of suits which are not maintainable, that shall be thrown away from the very threshold. अगर दे में भी निप इनटू दी पट, इससे पहले कि वो फूल बने, कली ही उसको मसल दीजिए ताकि वो आगे न बन पाए हो. So I have challenged the maintainability of the suit because the suit, the plaint, in the way it has been filed, on the very perusal of the amendments made in the plaint, the suit is not maintainable. There are so many legal provisions by which bars the suit.
Mr. Yadav, now recently Justice Chandrachud-led bench of the Supreme Court has held has observed that ascertainment of religious character with regard to such places of worship is not barred under Section 3 of this Places of Worship Act 1991.
This Chandrachud I never said. What Justice Chandrachud has said in this case, that a commission was issued for the inspection of that particular premises. We said that it is against the Places of Worship Act. The Supreme Court said, no. If there is making any sort of inspection, simply the inspection, by doing the inspection, the religious character is not going to be changed. This Supreme Court has said.
So we can take this particular case maybe an exception to the Public Places of Worship Act 1991?
No, not exception. Public and Places of Worship Act, all the provisions are directly applicable in this case. Completely applicable. This case does not come in the exception of that case, of any of the provision of the Places of Worship Act.
How this particular act, if this is applicable in this present case, so how does the presence of this act affect your stand in before the court?
They admit that there is a mosque. They admit that the Muslim has a possession. There is a clear-cut evidence on their own admission that what is the present situation is prevailing at that very moment. It was in the same way on the 15th August of 1947. So the very object of the, if you go to the very preamble of the Places of Worship Act, it says that this act is enacted to protect, to prohibit the conversion of any religious place to any another religious place. And this act speaks about the religious character. It does not speak about the religious structure. Both have got a distinct meaning. Suppose you are coming in my chamber, so the character of this room is a chamber. Why it is chamber? Because the acts which are going to be performed here, that relate to a professional lawyer. I sit here, I give the consultation, I give the dictation, I prepare the case. So very nature of this room is It is a chamber. It is office here. It is an office of a lawyer. Tomorrow, suppose for a moment, I replace all these books, my briefs, my table, my chair, everything outside this room. And I keep some sofa here, some table. The nature of this particular room will be changed into from an office to a drawing room. This is material. The structure is immaterial. What top of religious ceremonies are going to be performed according to the personal law, that is the determining factor. What is the religious character of a particular place of worship?
Do you think this particular case has been put into an unending litigation, or it could have been already settled in the top court or the Supreme Court itself?
No. The Supreme Court, the matter was went to the Supreme Court for an interim order. The order by which the commission was issued, that was challenged by us before the Honorable High Court. Unfortunately, the brief question was dismissed, and thereafter we challenged the order of the High Court before the Honorable Supreme Court. But the trial of the case shall be done here. This is the proper court. This court is a competent court to try the suit. Supreme Court is not a trial court. So case will be tried here in the district court.
Okay. My last question is with regard to what is being claimed or what is being running through the media is with regard to the presence of shivling. What exactly do you think? Is there a shivling?
I shall have no comment on media, because media, there is a parallel trial of the media is going on. I am not concerned with that. And what media is reporting, what media is saying, I am not afraid to that. It is not going to come to change my nature. I am an advocate. Whatever I will do in the job in the court of law, that will be determining factor. Media is showing something else, which is not in the case. Media is showing all these things which are not the subject matter of the case itself.
Thank you so much, sir, for giving your precious time for this particular interview. Thank you so much.
Subscribe to our YouTube channel and click the bell icon.